Welcome to the Bombay Bar Podcast, a show where we share the rich history of the Bombay Bar Association through our members, past and present. Today we have retired Justice Rohinton Nariman of the Supreme Court of India. Rohinton, to start at the very beginning, as Maria said in The Sound of Music, I believe your mother was a very strict person as far as your lessons and your studies were concerned. Did that sort of serve you well in later life?
It probably did. My mother was strict, but she never lifted her hand. So her way out was to scream at you. And then you got used to the screaming, so it didn't really bother you too much. But yes, she was constantly at you. I mean, you were like a little performing flea. She wanted you to be good at everything, to be good at your sports, to be good at music, because I went to a piano teacher, which happened to be a disaster. And
Disaster for you, not for the teacher.
yes, for both perhaps. And now that I look back, probably for both. But yes, she was the driving force in my life in every way, including the fact that I had to go for my priesthood when I was only 12 years old.
Now, one of the major upheavals of your life was when, as you said, your father became the additional Solicitor General for India and the family moved to Delhi. What was it like to suddenly find yourself leaving your old friends, leaving your lovely home here and going off to a new place, starting, in a sense, life all over again?
It was incredible. You move from a tiny little flat into a huge bungalow with an even bigger garden in Delhi. That's the first thing that hit you. The second thing that hit you was the vast spaces in Delhi. In Bombay, you went from home to Cathedral School, which was probably 2 kilometers at best, and not very much beyond. Juhu was like some massive excursion trip. But in Delhi, to have to go from our house to the university took a good 1 hour and must have been something like 20 kilometers away. The fact that you had actual seasons in Delhi, unlike Bombay, because summers were very hot, winters were very cold, were all things that conduced, I think, to opening you up as a human being.
And what is that story about your old family retainer? When your father became the additional Solicitor General, you had an old retainer called Babu.
Yeah.
And what was his comment on your father's elevation?
His comment was in Gujarati when he was told, "Ke sahib vella magistrate tha." Because to the old retainer, the magistrate perhaps was the biggest thing that he had ever seen in the law.
In Delhi, you first went to Sri Ram College of Commerce and then to the Delhi Law School. You had many friends there, didn't you? Who stuck by you sort of later. I've noticed, for example, that at all your major functions, you have retained contact with your school friends, your college friends. You always invite them over. You're in constant touch with them. Do old friendships matter a lot to you?
Yes, they matter very much. I've kept in touch with a number of school friends, number of college friends. As a matter of fact, in my very first week in the Sri Ram College of Commerce, I made friends with Arun Jaitley on the very first day of being in Sri Ram College. As a matter of fact, Arun was looking out for me. And he found this little fresher and took him to a particular table right at the end of the canteen. And we were locked in conversation, I remember, for 1 hour.
Oh.
And after that, we became the closest friends possible. So yes, within 1 week in Sri Ram College, I made some very good friends. And I've kept in touch with all of them. Yeah.
And then Harvard Law School happened. Did you find a vast difference between the way that law was taught in India as against what it was in America?
Yes, I did. But in favor of our Indian education, the Delhi Law School was a class apart. We had a semester system. And we had, I think, it totaled up to 30 subjects at the end of 3 years. Because every 6 months, you gave 5 papers. And we had outstanding teachers, I must say. So the Delhi law faculty was an excellent faculty. It was also unlike all other faculties at that time in that we studied by the case method.
Uh-huh.
Now, you didn't, for example, pick up the Contract Act and move from section 1 to section 200 and odd. What you did was you picked up one particular section and you had a judgment on it, preferably a dissenting opinion as well. And you were then made to think for yourself that was the dissenting opinion actually right or was the majority opinion right? And that's what made life very interesting. Getting to Harvard, of course, was a different thing, ball game altogether. We had a very young man at the time called Roberto Mangabeira Angar, who taught us jurisprudence. Now, he didn't teach us the way other teachers taught us. There was no Socratic method here. He would pace the floor up and down like a tiger without looking at anybody and let fly, and then suddenly walk out. He was a brilliant chap and a very nice man. And 30 years later, he taught my daughter as well, because he was 33 when he taught me. So he must have been 63 when he taught my daughter. So we had all these great teachers. Then we had Professor Mansfield, who taught us the very esoteric subject of ancient Hindu law.
Oh.
So we did Dharma Shastra law as well. And I remember I had written a paper, apart from the main paper that I wrote, on the difference between penance and punishment.
Wow.
I can't lay my hands on it, unfortunately. The main paper was done with Archibald Cox, another very famous man, who was Kennedy's Solicitor General and who was fired as the special Watergate prosecutor. And I had done a comparison between how we treated our scheduled castes and tribes as opposed to how they had treated the black.
Oh.
And I remember his cross-examining me on the Indian portion continuously because he wanted to learn. And it was a great opening of the mind for me to, to sit with these people and converse on these subjects.
You started as a junior like all juniors do in the profession, when you entered the profession. I'm sure you must have had your own fears, your own apprehensions about what the future would hold, your own anxieties. And you joined K.K. Venugopal's chamber. And I remember you mentioning that he was very good to his juniors. He paid in those days, I mean, not every senior pays their junior. He paid about 4,000 rupees a month. And you said that you were in a tenanted premises and that money went virtually into all the rent. And of course, tenanted because you didn't want to stay in the shadow of your illustrious father and wanted to make a distinctive career path. So those were very different times, weren't they?
Very. As a matter of fact, after I came back from New York, I made the mistake, and I use the word mistake advisedly, only professionally, of coming to Bombay to be away from my father. And I was in Bombay for about 3 years. But then the Lord balances everything out. So that I made the dearest friends, of one of whom is sitting before you. And our chamber was a great place. I mean, we had so much fun together.
Chamber number 1.
Yeah, and we are all very, very dear and we're all very close. I might name some of them. It begins with the Venerable Kharshetji Baba and goes on to Iqbal Chagla. These are the senior people. And of course, we had all our lovely seniors, beginning with Avinash Rana, who's 96 today, and who is probably the closest to me of all these people. A delightful and lovely human being. We had Niranjan Vyas, who then became a High Court judge. We had Vatsal Chhatrapati, who again is very, very close to all of us. We had Sandeep Thakur, who unfortunately is just deceased. Man who was, again, a person who was rounded. He knew a lot about a lot of things. He was a great photographer, apart from being a great constitutional lawyer. We are all these delightful and beautiful people. And then, of course, we had the senior junior who was always doing better than all of us, Janak Dwarkadas, who's again my dearest friend today and who's right on top of the bar. And we had Jimmy Avasya, who was a genius in his own right. In fact, he should have become some kind of TV mimic or critic or whatever. So we had a homogeneous, lovely chamber consisting of all these people. And what, of course, I could not do professionally, I got in abundant measure otherwise.
In the initial years in Bombay, in Delhi, I'm sure like every other junior, you would have faced failures in court in the sense that you argued matters, you lost them perhaps. The famous case which you did in your very initial years, this Prakash Aminchan Shah, where you appeared before a constitutional bench, 5-judge bench, you lost despite everybody, including the judges, thinking that you had put up a brilliant performance. Did these sort of initial failures dishearten you? How did you react to these failures?
Prakash Aminchan Shah, of course, was a case which was a challenge to the Bombay Town Planning Act. Now, I thought I had two complete aces up my sleeve. One was that the Constitution Bench judgment of Shantilal Mangaldas, a 69 Supreme Court judgment, which upheld the Bombay Town Planning Act, was expressly stated to have been overruled by a bench of 11 judges 6 months after. Unfortunately, the author of both judgments happened to be the same, Justice Shah.
Justice J.C. Shah.
So J.C. Shah did not explicitly say in the second judgment that he overruled the first. It took another 8 years for Justice Untwalia in 1978, in a combination of 7 now, to say that it was overruled. So if it stood overruled, it means the Bombay Town Planning Act should have been struck down. Then I also had another ace up my sleeve, which was that you cannot have two statutes leading to vastly different compensation in the hands of the same person. You cannot pick up a piece of land under the Land Acquisition Act and pay 100 rupees and then pick up an adjacent piece under the Bombay Town Planning Act, which would result only in 50 rupees as acquisition. And that was again settled by a bench of 7 learned judges, Justice Sikri's judgment, in the famous Nagpur Improvement Trust case in 1973. So armed with these two aces, I went to battle. Within the first hour, Justice Eradi asked me a question, which was something like, have you stopped beating your wife? And I told him exactly that. I said, this question is exactly, have you stopped beating your wife? If I give you answer X, you will say this. If I give you answer Y, you will say this. All the judges burst into laughter. And as a result, I think I got comfortable, they got comfortable. And the next 2 days were a breeze, because I must have argued for 3 days before these people. And they were so kind and so encouraging, even though they kept on at me on silly little things like, where is the compensation provision? I remember I pointed out section 67. And they said, this can't be it. I said, that's my point. There is no provision. They said, no, that cannot be so. Anyway, the next day they came armed with whatever and they said, yes, we will read this into it, read that into it. And this kind of thing went on. Finally, when the judgment came, it was Justice Venkatramaya's judgment. He got over my 2 great points by first dealing with the first point and saying that, look, Justice Untwalia in 1978 may have said virtually overruled. But then we read it for ourselves and we don't say it's overruled, even though 7 judges is binding on 5 judges. So I was very happy to note there was no way out of my argument. I may have lost, but there was no way out. So he said expressions like virtually overruled we don't accept, and we look at it ourselves and we say it's not overruled. All right. Now that's no way to get over the argument, but they got over it that way. And equally with the Nagpur Trust case, again they said no, acquisition under town planning is different because you will get a plot, etc. But then that again didn't deal with what 7 judges said. That it doesn't matter what your object is specifically. Your object may be town planning, maybe something else. If it results in different amounts being paid for acquisition, it is bad in law. They did not address that issue equally. Right. So I feel that it was a great moral victory for me.
And shortly after that or around that time, you were engaged to appear with the great Nani Palala in the Minerva Mills case, and perhaps the only junior. And that was because of Jimmy Dadachandji, I believe. What was it like to be appearing with Nani? You had seen him, I assume, in court, and
Yeah.
you had, but working with him would have been a different experience.
Absolutely. As a matter of fact, the Minerva Mills case was argued in the year just before I left for Harvard.
I see.
I finished my LLB and then I was in the Supreme Court for 1 year, after which I went to the Harvard Law School for my LLM. It was in that year that Dada Chandji came to our house, and I'll never forget. He said, "This is the brief of your life." And he said, "I am giving it to you because I know you're a bright young boy. Of course, it's being given to you because there's no compensation. And you will be assisting the great Nani Palkhiwala throughout. You are the only person assisting him. And I will depute Shailendra Swarup along with you from my firm." And so it happened. And I remember the very first meeting with Palkhiwala was a meeting where he was absolutely humble and down to earth. First thing he said is, "I want your thoughts." And I was a little boy out of college. So I said, "This is amazing that a man who's a genius like this wants my thoughts." Anyway, I gave him my thoughts. He listened very attentively. And from the moment he opened his mouth in court, you knew that this was a genius of a different order. I have never seen an advocate like him. Now, I can tell you, the substance of Minerva Mills was a challenge to two articles which were left in Indira Gandhi's 42nd Amendment. A large part was done away by the 44th Amendment, but these two articles somehow remained. The first was Article 368, 4 and 5, which purported to do away with the basic structure doctrine and which said that no court can get into a constitutional amendment. No court can ever strike down a constitutional amendment. And the second was Article 31C, which was an article which gave primacy to all directive principles of state policy over fundamental rights. Now, he formulated his submission on Article 31C thus. See how simple, lucid, and brilliant it is. He said, Article 31C turns the Constitution on its head. Sentence 1. Sentence 2. Now, how does it turn it on its head? Whereas fundamental rights are meant to be enforced in courts of law, they have been rendered unenforceable. And whereas directive principles of state policy are expressly not enforceable in courts of law, they have been made enforceable. You see how this strikes you. It's brilliant. And once something is formulated in this particular way, it's almost impossible to answer it except to accept Mr. Palkhiwala's submission. He did the same for Article 368, 4 and 5. And I remember in the course of this huge case which went on for almost 4 weeks, Justice Untwalia, who was the garrulous judge in this 5-judge bench, went on and on about how we had accepted socialism and that Mr. Palkhiwala was arguing essentially for capitalism. And Mr. Palkhiwala heard him out. He was very nervous, incidentally. And he kept on tapping his cheek for that 20 or 25-minute peroration of the judge. And at one point, butted in to say, "Has your lordship quite finished?" So Justice Untwalia said, "Yes." And then Palkhiwala drew himself up and said, "Not even a lunatic," and he shouted the word lunatic, so much so that everybody got a shock, "would ever think of crossing the wall," that is the Berlin Wall, "from West Berlin to East Berlin." Now, answers like this are like an atomic explosion which devastates completely what the other side has to say. And it was things like this that one learned from him.
Also, it's a little off topic of Mr. Palkhiwala, but the Minerva Mills case was an important follow-up to the Keshavananda Bharati case, whereby a wafer-thin majority, 7-6, the basic structure doctrine was laid down. And contemporaneously now, 50 years later, this was 73 judgment. Incidentally, it's the same day that Sachin Tendulkar was born, 24th April, 1973.
Yeah.
But it's an important doctrine. It's been debated at the moment. It's been vehemently criticized. It's been equally passionately defended. What would be your thoughts on the basic structure doctrine in the Indian democratic polity at the moment? I mean, how important do you think it is?
See, basic structure is really implied limitations. Another word for implied, that there are no express limitations in the sense that the amending power is plenary. We have 4 types of amendment in our constitution, 2 of which are reflected in Article 368. And it is very difficult to say that if you do not follow or you follow the drill of Article 368, then a constitutional amendment can be struck down on substantive as opposed to procedural grounds. But that is exactly what the majority in Kesavananda Bharati held. What they held was, and this was largely based on many writings, including an early article by Dr. Dieter Conrad of Heidelberg University. And Dr. Dieter Conrad spoke of the Weimar Constitution in Germany, Hitler's rise, the complete effacement of that constitution by using that constitution itself, and the safeguards that Germany has post-World War II had in its constitution. And he gave some very telling examples to say that, suppose you were to say that you followed the procedure for amendment, would the following amendments stand scrutiny by any court? First, suppose you were to abolish the constitution and you were to say bring back monarchy, the King of England. Suppose you were to efface altogether Article 21, which is a personal liberty article, and convert a democratic system of government into a dictatorship in one stroke. Suppose you were to give the power of amendment no longer to Parliament, but to the executive, to the president. Things like this. Now, the obvious answer would be that you cannot do these things. Why
You
can
pointed
you
out
not?
extreme cases.
Yeah, but why can you always point out extreme cases to test a proposition? Why can you not do it? You can, because there is no express limitation in that sense. But what was read in was implied limitations to say that we in our preamble have chosen the democratic way of life and chosen certain values. If those values are effaced, then nothing remains of the Constitution. And if nothing remains, then it damages or destroys what was called the basic structure. Now, what people forget today when they raise a controversy which was buried long ago, is that it was buried because of the following. Immediately after 1973, Mrs. Gandhi lost her election case in Allahabad, and while the appeal was pending, she rushed through the Constitution 39th Amendment Act. In essence, she said that she was above the law. Now, the 39th Amendment Act was procedurally perfect. The necessary two-thirds majority in both houses was there when the president signed the bill, and it was also sent to the states for one half of the states for ratification. So what could one possibly say? One could only say that it actually damaged the basic structure in various ways. The great thing was that of the 5 judges who heard it, 4 were minority judges in Kesavananda Bharati.
Who had not accepted the
Exactly. Now, those 4 had said there is nothing like a basic structure. But they were bound by the majority holding, which was 7-6. Applying the majority holding, they were forced to say they were wrong. And each one, therefore, picked up a facet of basic structure to strike down this horrendous amendment. That's point 1. Point 2. Immediately after, when Mrs. Gandhi lost the elections and the Janta government came, Parliament actually accepted basic structure. How did it accept basic structure? It said that when an emergency is to be declared in future, Articles 20 and 21 cannot be suspended. Correct. Now, if they cannot be suspended, it only means that they reflect a constitutional value of such importance that even during an emergency, that is, an armed insurrection from within or some war from outside, cannot possibly efface these provisions. So the second point to be made is that Parliament has now accepted basic structure.
Right.
Third, there was a 45th Amendment Bill that was passed by Shanti Bhushan, or tried to be passed by Shanti Bhushan when he was Law Minister. That amendment bill reflected 5 values as basic structure and then said that if you want to change them, go to the people in referendum. That also failed. So that's also gone now. And most important of all, the case in which I appeared, Minerva Mills. Minerva Mills struck down 368, 4 and 5, which attempted to do away with basic structure, as I told you, which was the 42nd Amendment. The court struck it down unanimously, saying that no, basic structure has come to stay. These articles are bad.
Right.
So according to me, you are raising today a controversy which doesn't exist.
Right. To move on with your personal progress at the bar in that sense, you became a senior advocate at a very early age. Everybody knows the Chief Justice lowered the age at the age of 37 a senior. Now, once you became a senior advocate, obviously the more difficult cases came to you. As they say, the terminally ill patients would go to a doctor, since you are now a senior advocate. Now, in these difficult cases, where you, for example, had a matter where you felt that one particular fact or a number of facts were destructive of your case, how would you approach it as a counsel when you were as a senior counsel? How would you approach it before a bench?
My advice would be honest at all times. Never try to hide a fact against yourself. If there is an answer to that fact, certainly put the answer to the judge. But never try and hide something against you. You will get the judge on your side if you honestly tell him that, look, there is this fact, but there is also X and Y. First bit of advice. Second, there is no case, according to me, which is so bad that it's unarguable. Now, I will give you an example of almost inarguable cases that I have argued and succeeded in. One was before Justice Rumapal, where it became almost inarguable only because a certain factory had been taken over under the State Financial Corporations Act of 1951 in UP. And the person who was involved, the owner of that factory, went to court. Now, he hid the fact that he had already applied for an injunction in a district court, had failed in appeal, and then abandoned that remedy. Then he hid this from the writ court, and he went in a writ for the same relief.
So clear suppression.
Finished. So both the single judge and division bench said, no question, there is suppression, out you go. Almost inarguable case. What do you tell the judge? Now, I appeared before Justice Rumapal, and she started off very strongly against me, but I realized on some other set of facts. So I said, no, ma'am, this is not my set of facts. There are a lot worse. So she looked up and she said, lot worse? I said, yeah, you seem to have some other brief before you. Just please take up item, whatever it was. She said, yes, this one. So I said, look, I have lost on the ground of suppression. There is some explanation that is offered. I don't buy it. I told her, honestly. However, if you allow me to even argue for 1 minute, I will tell you that the state government has behaved extremely arbitrarily in this case. She said, oh, is that so? So I immediately diffused the one fact which should have killed me and got into the state government's arbitrariness. She heard me out for 10 minutes, issued notice and stayed the entire proceeding. Then she put it before herself on a Friday after notice matter. And I reminded her. I started again by saying, this is that case of suppression. And then told her how the state government had behaved. The state government had no answer and I succeeded. Now, this shows you also that if you are brutally honest with a judge,
Be straightforward.
absolutely, you tell the judge what it is. You even get the judge on your side by saying, look, I don't buy the explanation. And then finally you point out how the other side is wrong. You have a good sporting chance of succeeding.
You accepted judgeship when Chief Justice Lodha asked you to come over to the bench, and at a time when you were at the peak of your career as a counsel, etc. What motivated you to go to the other side? And of the two, which do you find more satisfying?
See, as a counsel, there's only so much you can do. You're earning a lot of money. But there's not very much you can do which is soul satisfying. As a judge, you can do a huge amount more. And I felt that, look, a stage had come in my career where I had made more than enough money. So it's time to give back. It was only for that reason that I accepted judgeship. The 7 years as a judge were perhaps the most difficult years of my life. Because you grind very hard from morning to night. The sheer volume is staggering. Volume of cases that you deal with. Then, of course, you are deciding very, very important things for the country. So you have to be very careful when you decide. But I can only say that my stint as a judge was perhaps my defining moment. Because I'm naturally judgmental. And I didn't find it difficult to reach what I thought was the correct conclusion. The only thing was, I wanted to be 100% certain that I have not gone egregiously wrong.
And one of the noticeable features of many of your judgments is the fact that you, apart from the law and the dry sections, and you introduce elements of literature, you introduce elements of history. In one, sales tax or wealth tax judgment in Bangalore, you introduced a story about Winston Churchill.
Churchill's unpaid bill.
That's right, in the Bangalore club case. In another case, you introduced the story of Peter the Great of Russia, who said one day decreed that all men with beards will have their beards off. And you used it as an example of arbitrariness, state arbitrariness, etc. Do you think as a lawyer, as a person, as a judge, having varied interests, having knowledge of various non-legal subjects helps a great deal in the law?
Absolutely. In fact, if you read the opinions of some of the great American judges, I hold them in the highest esteem, particularly Justice Jackson for his language, and of course Justice Holmes for his thoughts. You will see exactly what I mean. Because it is their judgments which are the law as literature. They are beautiful to read. They make so much sense. And philosophically, they are very sound. So you have everything all in one. And I honestly feel that it is very, very important for you to get into every facet of life, because ultimately, what is the law? It reflects life.
Right.
You can have a patent case before you. Now, if you do not know anything about chemistry, very difficult to appreciate the case. And if you know nothing, admit you know nothing and begin to learn, correct? So it is a great learning experience all the time to keep your mind as nimble as possible and to get into new areas all the time.
So most lawyers, you would say, should be encouraged to have a passion for something other than the law.
Absolutely.
And to sort of just further this thought a little, the bar has provided a number of judges. The pool for judges comes essentially from the bar. And I've been long enough in the profession, 47 years now, to have known many of them personally. And you sort of find that you're sitting one day in the library, there's a guy sitting next to you. The next day he becomes a judge and he's now tasked with making momentous decisions, sometimes affecting the country, etc. Do you think that the members of the legal profession make the best judges? I know there are constitutional requirements of 10 years, etc.
Of course, there are constitutional requirements. To become a High Court judge, for example, you need to be a lawyer of 10 years practice. But it's a very interesting question. According to me, no one set of people should have a monopoly. I don't see why any person should not be a judge if he has qualifications which show that number one, is intelligent enough to appreciate the law.
Correct.
And number two, is a essentially good human being. I mean, these are the two things that I would look for.
I always say industry, intelligence, and integrity.
Absolutely.
Those are the...
I agree with you completely. And left to myself, I would love to have a mix of persons from every walk of life.
But offhand, can you think of, maybe even from American history, of a non-lawyer judge doing brilliantly?
I can tell you something amazing. Undoubtedly one of the greatest Chief Justices of the United States was Earl Warren. Earl Warren was only a lawyer, not a practicing lawyer. He was governor of California for an extremely long time and was a politician. He was made Chief Justice directly, because in their system, anybody can be picked up and made Chief Justice. He was the quintessential non-lawyer politician who made one of the greatest ever Chief Justices.
Really?
Yes. Because his famous question would always be, is this right? Is something that you are putting to me, is it right? So he put justice above the law. And it is only his political skills by which he was able to have a unanimous decision in Brown versus Board of Education, which undid Plessy versus Ferguson, the separate but equal doctrine,
Right.
and said, no, black children must integrate with white children. It's no good saying that you have a black school, which is equally good, but they must stay apart.
I see.
So it is he who worked on the southern members of the bench, because the South were the old plantation owners who were still in favor of the old Plessy versus Ferguson doctrine. And he had to work around them through dinner diplomacy and other means. And finally, he even got Justice Stanley Reed on his side, which was something fantastic and which only a politician could do.
You seem to lay a great deal on importance on dissents in the law. And you yourself, being a very independent, fiercely independent-minded person, are party to many dissents. In your view, how important are dissents or a dissenting judgment? What role do you think they play in the progression of the law?
It was best put by Chief Justice Hughes of the US Supreme Court. And what you are really doing by a dissent is you are appealing to the future. Now, how do you appeal to the future? You appeal to the future by pointing out the flaws in the majority judgment. And being a dissenter, again, you do not have to necessarily compromise to get other people on board. So this is a view which is your own real view. And if it is strong enough, both in terms of reason and justice, at some future point of time, that may become the view of the court.
Rohinton, you have been a religious scholar, an acknowledged religious scholar, and of comparative religions, really. And I know that you are a deeply religious person who tries to practice life according to the Zoroastrian credo, which is your faith. Do you think it's right for a judge to, or to what extent would it be right for a judge to bring his own religious beliefs into what he decides?
I think it is very important first for you to realize that you have taken a very different oath. Your oath is to the Constitution and the laws. Now, if the Constitution says something which conflicts with your religious belief, the Constitution prevails.
Right.
It's a very difficult thing. But the Constitution usually will not, because both are moral precepts. At the end of the day, they are both moral precepts. How the Constitution views a particular moral precept may be difficult from what your religion tells you about a moral precept. But you must be true to your oath first.
No, you were also the Solicitor General of India for about 2 years before you became a judge. And that must have involved a complete, how shall I say, change in approach, change in mind. Here you were as a senior counsel lambasting the government in many matters. Now you're in a position where you've got to defend government decisions, etc. Did you find that change very, very dramatic? Did you find it very difficult to adjust to the changed circumstances? And in that context, I want to know, what do you think is the role of the law officer? Is he merely the mouthpiece or the rubber stamp of the government? Does he have a certain discretion in the manner in which he presents government's view, etc.?
First thing that we must realize is that this is one of the pleasure posts in the Constitution.
Pleasure posts.
When you are Attorney General, you are at the pleasure of the central government.
Okay, in that sense.
Which means the central government must have confidence in you. If it loses confidence, it can get rid of you instantly.
Right.
So one must keep that in mind.
And it is entitled to, justified.
The client may take up any other person as Attorney General,
right,
because he's lost confidence in you. Having said that, you have a completely different duty to the court. And this goes for any lawyer, from the Attorney General downwards. Your duty to the court is paramount. You have a duty to your client, you have the duty to the court. And where the two conflict, the duty to the court comes first. I have always believed this.
As a law officer also?
Also as a law officer, but as a lawyer generally. And therefore, very often as Solicitor General, I have honestly told the court that, look, this is what government's position is. But since you are asking me, my position is X.
I see.
I have said that often. And I've been appreciated for it. Now, it is important, therefore, for you to first realize that you are part of a system where you have to uphold the rule of law. This is the single most important thing. And you uphold the rule of law best by first serving the court and then serving your client.
You know, one of the most noticeable features of your tenure as a judge was the fact that you were very encouraging to well-prepared young lawyers. Was that a conscious decision?
Quite honestly, I love young people. And if I find that there is a sincere young man and he's making an absolutely absurd argument, I will never tell him he's making an absurd argument. You gently guide him into making the right argument because you see the level of sincerity, you see how much he's worked. You can test these things very easily. On the other hand, if you find that there is a person who's trying to mislead you or a person who has not worked, again, if he is young, you give a lot of leeway. And you try to bring them on the right path in whichever way.
Right.
By telling them, look up this, look up that, work a little, come back again after you have worked. The important point is to be positive at all times because every young person ultimately must attempt to be a good lawyer. And every young person also may well be struggling and in difficult circumstances.
There may be other factors which...
Yes, there's so many other factors. So I feel that a little kindness to young people is a very important thing for every judge. And that I have always kept in mind. And I've always tried consciously, therefore, to say that, look, every young man deserves a lot of leeway.
Right.
The same doesn't go for senior advocates.
As they found to their cost.
Often, by the way, I have been told that if there's a difficult case, leading seniors would say, you argue it, you stand a much better chance to a junior.
Thank you very much, Mr. Justice Rohinton Nariman, into bracket retired. It's been a real pleasure talking to you.
Thank you very much. I have never been Mr. Justice to you. I have only been Rohinton.
As Justice Nariman rightly said, to be a good lawyer or a judge, one has to be a multifaceted person. After all, what is the law but a reflection of life itself? Thank you for watching the Bombay Bar Association podcast. Do subscribe to our channel for more such videos. We also have an audio version of the podcast where we delve a little bit deeper. Feel free to check that out as well. It is available on all podcast apps. Thank you.